Good morning, everyone. The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. Please make sure your devices are muted until your case is called. Once your case is called, please unmute your device and state your name after the attorneys have placed their appearances on the record. The court will call the case of Ypsilanti Township versus Jameson Mitchell, case number 25T00181.
Paul Barnett on behalf of the township.
Good morning, Your Honor. This is Matthew Mansour, Assistant Public Defender. I am here with and on behalf of Mr. Jameson Mitchell, who appears via Zoom from the Washtenaw County Jail. Mr. Mitchell, can you state your name for the judge, please?
I look like my attorney. Jameson Mitchell. You don't look like my attorney, my boy.
Yeah, it's okay. We work in the same office.
But yeah, Jameson Mitchell.
Thank you. All right, today is the day and time scheduled for a pretrial in this particular matter.
Yes, Your Honor, that is correct. To my understanding, Mr. Mitchell wants to set this for final settlement conference. Is that correct, Mr. Mitchell?
Yep.
Mm-hmm.
And Your Honor, Mr. Lebo would like me to address bond for Mr. Mitchell whenever you are ready.
He has a PR bond, $20,000 PR with a GPS tether.
Correct. Yeah, it was just a quick modification if the court would consider. Apparently, the complaining witness and Mr. Mitchell live very close to each other, I believe, across the street. The complaining witness appears to live on lot 33 on 2580. So if the court would incline removing the tether and just allowing a no-go to, since they are so close in vicinity.
Mr. Barnett?
I mean, I'm not sure why that really matters. I mean, I'm not real comfortable with agreeing to removing the tether, especially, I mean, he's on a PR bond.
Can I say something?
That's up to you, your attorney, sir.
No, Mr. Mitchell. I mean, unless you want to talk about it in another breakout room. But is that the request you were trying to make? You wanted to be off the tether?
That's the request I'm trying to make.
Okay, then they heard it and they don't want to do it.
Well, you want to talk to Mr. Mansour more about this? Mr. Mitchell?
Yeah.
You mean yes?
No, I'm good.
Yep.
Y'all trying to keep me on tether though? That's crazy though. It's crazy.
All right.
We don't see the at trial, I guess.
I'm sorry, what did you say, sir?
That I would rather not be on tether.
I heard that part of the request. I asked you a simple question as to whether you wanted
I said no.
Did you just interrupt me when I was talking?
I said no.
Sir, do you want to be held in contempt of court this morning? Defendant's motion for the removal of the tether is absolutely denied. Final settlement conference in this particular case will be scheduled for June 27th, 2025 at 9:30 a.m. Jury selection will be scheduled for July 11th, 2025 at 8:30 a.m. Bond is continued.
Your Honor.
What we'll call the case of Ypsilanti Township versus Kimberly Robinson, case number 25T00128.
Paul Barnett on behalf of the township.
Allison Muller here on behalf of Kimberly Robinson. Ms. Robinson, can you please unmute and then go ahead and state your name?
Hello, can you hear me now?
Yes, please state your name.
Hello,
Please state your name.
Kimberly Boyd Robinson.
All right, we're here for a pre-trial today and a bond violation.
Yes, Your Honor. For the underlying pretrial, we would be asking for an adjournment on that. If the court would grant us that, we'd like to talk about the case a little bit more and go over or talk about plea negotiations further. We are prepared to move forward today with the violation.
All right, so on. Let's see how far back this goes. So she was originally arraigned on March the 22nd and referred to community corrections. And then she failed to appear for a pretrial on April the 7th. And in addition to that, she had not been appearing at community corrections. So she had two violations in essence. And she saw the magistrate on May 13th. Looks like she got picked up on May 13th. So therefore, she was failing to appear and failing to report to community corrections. You have a right to have a hearing on the bond violation, ma'am, at which time if it is found that you violate the terms of your bond could be revoked. Understand that part, Ms. Robinson?
Ms. Robinson, do you understand that?
I'm sorry, no, I was having a hard time hearing. I had to get headphones. Could you just repeat the last part real fast? My apologies.
You failed to appear for court on April 7th and you failed to test at community corrections based on a violation report dated April 1st, 2025. You're entitled to have a hearing on this, at which time if it's found that you did violate the terms of your bond could be revoked. Do you understand?
Yes, Your Honor.
All right. What would your client like to do, Ms. Mueller?
Your Honor, Ms. Robinson will admit today to not reporting to corrections and missing the last court date.
Okay. Ma'am, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may lower your hand. Ma'am, is it true that you failed to report to community corrections and failed to come to court on April 7th?
Yes, Your Honor.
All right, I do find that there's a willing and knowing admission to the violation. Are you satisfied, Mr. Burnett?
Yes, Your Honor, thank you.
Defense is satisfied as well, Your Honor.
Thank you. Is she testing now?
Your Honor, we wanted to address that today, and this should have been addressed previously, but we are asking for permission for her to test near where she lives in Adrian. And she can report and do that within 24 hours if the court would allow her, and she will get testing at Adrian if that's approved.
Yes.
I'm not
And
sure.
if-
The answer to my
Oh, just a
question.
minute, Ms. Robinson. Your Honor, no, I don't believe Ms.
But I
Robinson.
could,
Ms. Robinson, have you tested?
I have not. And I did go to community corrections Friday upon me being released, and they said that there was an order. And I told them that, I asked them if I could, and they said that there's not an order, that just to get a hold of my probation officer. What happened? I'm sorry, I had to step out.
Or just
My grandma's
just
house was a full house.
Just a
But,
moment, Ms. Robinson. Let's leave it there for just a moment.
I'm reporting to community mental health out here. I'm having that switched over, and I'm not sure where I would go and test out here, but I am I'm thinking outpatient treatment or just for my mental health. I'm saying maybe inpatient treatment, because I'm dual diagnosed, and I'm going to be doing that today. So I'm not sure where I could go and test for the court, but
Ms.
I am
Robinson?
going to.
Let's just leave it just there for a moment, okay? We're just talking about testing right now. So the judge just needed to know if you've tested, okay? And I think we've answered that. Thank you.
Okay.
Mr. Barnett, do you have any input on this?
I'm gonna leave it in your discretion. I don't mind if she tests closer to where she lives, if there's an appropriate place. I mean, that seems to make sense.
Did you say Adrian or Albion?
Adrian, Your Honor. Yes, my father was in Albion, and that's why I'm just not sure where I've asked and inquired, and I'm not sure where they're doing testing out here unless I can go to the courthouse.
I don't know if you asked that.
In 2021, it was Courthouse Commons. They were doing things there, and I
Ms.
just don't
Robinson,
believe
I'll
that
help
they're
you.
doing.
I will help
Okay,
you find
thank
somewhere to
you.
test, okay?
Okay.
Defendant is allowed to test
No.
in Adrian if she can find a place. If not, she needs to come here and test. She needs to test within 24 hours.
Right.
Absolutely.
Yes,
Thank you,
Your
Your
Honor.
Honor.
Ma'am, if you don't test within 24 hours, your bond's gonna be forfeited and you're gonna have a bench warrant. Do you understand?
I understand, Your Honor. Yes, Your Honor. And I'm also I'm on probation also with the OC, so that's why I'm just trying to like have everything on the same page, because I told my probation officer yesterday, and I'm sorry I haven't been able to talk to my lawyer, but I told her yesterday that I am going to be working with community mental health, and it'll just be a lot easier for me to do it out here. I'm not sure one way or the other, where if I'm going to stay out here or where I'm going to go. But I just want everything, I'm saying, to be on the same page. And I would like to test and show that, I'm saying, I'm not using substance. I'm dual diagnosed and having a really hard time. That's where I was at when I missed court. I was in the hospital. I talked to my lawyer about that.
Ms. Mueller, how long do you need before you're ready to come back?
Your Honor, I think just a matter of a couple of weeks, just probably the briefest adjournment that you have would be enough time.
June 4th, 2025 at 9:00 a.m. Thank you.
Okay, Your Honor. 4th. And this is on the violations.
Ma'am, this is for a pretrial. If you need to
Okay.
test. Okay.
Okay. Yeah. Yes. Okay. So this is for the pretrial for the charge, correct?
Correct.
All right.
All right. Thank you, ma'am.
All right. You're welcome. Thank you, Your Honor.
Okay.
All right. Mueller, can you call this phone number? Do you have this phone number? Or
I do.
You want me to okay. Thank you.
I'll give you a call. Thank you.
Okay. Thank you. Now I got to call community mental health. So I'm saying that I'm shaking. I can barely, and it's just.
Ms. Robinson, you should stop talking now.
All right. Yes. It's just
Ms. Robinson, you've got to
okay.
close out, but you're still on.
Okay.
The court will call the cases of Ypsilanti Township versus Jeffrey Murphy, case numbers 24T00131, as well as 23W002569B.
Paul Barnett on behalf of the township.
Assistant Public Defender Davey Lieb on behalf of Mr. Murphy. Mr. Murphy, could you say your name, sir?
Jeff Murphy.
Thank you. We're here today on a violation of probation. I'm gonna arraign you on your violation, sir. The violation alleges that you failed to drug and alcohol test on May 1st, May 7th, and May 12th. You have a right to have a hearing on the violation, at which time, if it is found that you violate the terms of your probation, you could be sentenced up to 10 days in the Washtenaw County Jail. Well, actually, this is your third violation, and so you could get the maximum penalty. In this particular case, you're charged with OWI, so the maximum penalty is up to 90 days in the Washtenaw County Jail. Mr. Lebo, what would your client like to do?
Your Honor, Mr. Murphy is being held on a felony matter that is currently pending. I'd like to adjourn the probation violation until after the preliminary examination on his felony, which is scheduled for the 27th,
Why would I do that?
in order to determine if the felony is going to continue to hold and which may affect his decision regarding the violation.
Mr. Barnett?
I'll leave that up to you. I mean, I don't want him out, but he's not going to be out.
When is the examination?
The 27th, Your Honor.
I will do that, but I'm gonna set a bond in this particular case.
Mr. Murphy, do you understand that?
Yes.
I'll adjourn the matter to May 28th. Is it for the actual exam or is it for the PP
It's,
conference?
Your Honor, that case not being held by my office, but I spoke to Mr. Murphy and he told me that it is for the exam.
Okay.
And was that June 28th, Your Honor, or May 28th?
May 28th.
Thank you.
May 28th, 2025 at 10 o'clock a.m. How long has he been in custody now?
Your Honor, I can check that right now. Mr. Murphy, I believe you've been in
Since
custody
April
for
20
around,
since April 29th.
Oh, okay.
and he does have a $100,000 10% bond in the felony, Your Honor.
All right. I'm gonna give him a 2,500 10% bond on this one.
Thank you, Your Honor.
All right, sir, we'll see you back here on May 28th, okay?
All right, thank you.
You're welcome.
Thank you.
Yep.
The court will call the case of Ypsilanti Township versus Victoria Johnson, case number 24T00462.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Lieb on behalf of Ms. Johnson. Ms. Johnson, can you state your name, ma'am?
Good morning, Your Honor. Victoria Johnson.
Good morning, Ms. Johnson.
Morning.
All right, we're here for a pretrial today.
Yes.
We're here for sentencing.
Oh,
Yes.
you're right. I'm sorry, for sentencing.
And Your Honor, I have reviewed the report and recommendation with Ms. Johnson. I do have one factual modification as well as some allocution argument. With regard to the factual modification, the report indicates that the police responded to a report of a locked vehicle in the park. That should read to a vehicle locked in a park.
Oh, okay. I was trying to figure that out.
As was I, Your Honor.
So that's why she was trying to go through the gate.
Yes.
All right, I will make that change.
Thank you, Your Honor.
Well, I should say the objection, Mr. Barnett, is that how?
No,
you
that's exactly what happened, I believe.
Thank you. As far as elocution is concerned.
As far as elocution, Ms. Johnson understands that operating while intoxicated is extremely dangerous, and that she's fortunate that she wasn't harmed, that no one else was harmed, and frankly, that her vehicle wasn't further damaged, there wasn't any further damage to other property. I do want to note that the crash that occurred here was essentially Ms. Johnson bumping into a post or a bollard on her way out of the park. It wasn't hitting another vehicle or hitting anything occurring at a high rate of speed. It was more of a maneuvering incident trying to leave the park. This is not a high BAC case. The assessor indicates there's no substance use disorder, so I'd be requesting no probation or non-reporting probation given that. I'm not entirely sure why the assessor believed it was necessary here, but I don't believe the presumption of a non-probation, non-jail sentence is overcome in this case, so I would be requesting that the recommendation be adopted with the exception of the probation and testing recommendations, Your Honor.
Mr. Barnett?
Your Honor, I've also reviewed the pre-sentence investigative report. I don't have anything factual to address. I'm just thinking about what Mr. Lebo said, but I do support the recommendation, including the probationary period. It was recommended by the assessor. They're in a better position to understand what would be appropriate, and I'm going to defer to their expertise on that. So I would ask you to follow the recommendations.
Well, the reality is whether it was hitting a baluster or any other device, it was a crash involved. So there is nothing needs to be overcome because there was a crash. That doesn't apply in crash situations.
Yes, Your Honor.
One second, I'm just reading the assessor's report more closely to see why they thought it was necessary in this case, other than there being a crash.
Thank you, Your Honor.
Actually, from what I see, it says that a referral to formal treatment or referral to community-based recovery is not indicated. I'm gonna grant the defendant's request in this particular case, and well, let me hear from you, Ms. Johnson, before I say what I'm gonna do. What would you like to say today?
Thank you for letting me speak, Your Honor. I would just like to say that I do want to take accountability for my actions, and I am aware of what I have done. And I do want to say that it won't happen again. I'm sure of that for sure. That's about it, honestly. This it's been a lot already. So yeah, I just want to take accountability for what I have done.
All right, I hope it was a wake-up call for you.
Yes, it definitely was, because I have 4 kids and it's already a lot on my mind. So yes, for sure.
All right. It is the sentence of the court, ma'am, that you serve 93 days in the Washtenaw County Jail, credit for 1 day served. The balance of that time is suspended. So if you do everything you're supposed to do, then you won't have to do any additional jail time. Okay?
Okay.
All right. Want to make sure you're hearing me because I saw your face. Like,
I told her to expect that, Your Honor.
okay. All right. You're to complete 2 days for a total of, I'm not sure what they wrote here. You're to complete two days for a total of 16 hours of community service. You have fines and court costs in this particular case for a total of $795. You're to report to the probation officer monthly via nope, you don't need to do that. I'm striking the probation. I'm going to give you some classes that you need to get done. And if you get all these things done, then you won't have to be on probation. You don't, then you might do some jail time and/or probation. Okay?
I'll be sure to get them done for sure.
Okay. You're to complete the alcohol safety program. You're to complete the MAD victim impact panel within 45 days. You are to not have possession or use of any firearm components, no alcohol, marijuana, illegal drugs, or anything like that in your home. They do want you to test. Let me see, you've been doing this since, this is relatively new. Are you testing now?
Yes, ma'am. I've been testing. I want to say I've been testing since January.
February?
February. Sorry, excuse me. February.
All right, I'm gonna have her continue to test for a moment. I want her to test at least 1 time per month. I'm gonna make it 1 time per month, and I'm gonna have a review in front of me in 90 days. That's on August 27th, 2025 at 10:00 a.m. You tell me you're not gonna use any alcohol or drugs, we'll make sure that that's not happening, okay?
Okay, and I also wanted to let you know that I do have a marijuana card, and I also have a letter for you as well.
A letter of necessity?
Like from the doctor?
Yeah, I need a letter of necessity for you to use the marijuana from the doctor.
Yes.
Okay. And when you send that over, I'll review it and make my determination. Mr. Lebo can help you to get that sent over, okay?
Yes, Your Honor.
Ms. Johnson, do you have my email address?
Yes, it's Victoria Johnson.
No, ma'am. Don't say that out loud. We're on Zoom and the world is watching.
Ms. Johnson, I'm sending you my email address in the chat.
Okay.
August 27th. at 10 a.m. I'll see you then. Hopefully you have all these things done and you can be done with us and we can be done with you and you never do this again.
Okay, thank you, and I won't.
All right, thank you. See you then.
See you.
The court will call the matter of Ypsilanti Township versus Martz Tullis, case number 22T00695.
Paul Barnett on behalf of the township.
Matthew Mansour on behalf of Mr. Martz Tullis. Martz, can you state your name for the judge, please?
Martz Tullis.
Thank you. All right, Mr. Tullis was before me on May 14th when he pled guilty to the new charge of OWI second from March 13th. I adjourned it for 1 week for him to be an inpatient or 60 days extended probation, but they're recommending 6 months to test within 24 hours. And did he go test?
Yes, I did.
What's the status of your treatment, sir?
I did my intake on this past Friday. And Sunday, I'm sorry, this upcoming Friday, she'll have openings. I'm going in at 10, which is the 23rd. At the Amherst house on Linwood. I sent the number and the address to Mr. Mansour.
Yes, he did, Your Honor. And Your Honor, I went over the report with Mr. Tullis. You are exactly correct about the last hearing. We want to thank you so much, Mr. Barnett and probation, for allowing him to have the opportunity to check himself into the program. He has checked himself. He is scheduled. He's locked in. He's good to go. He's going to be there on Friday at the
10.
At 10 at the Elmhurst home in Detroit. He's thankful for the opportunity. He's excited to get started and, better himself and work on himself. And the best part, Your Honor, you allowed him to do it on his own. You gave him the chance. He did test within 24 hours. He did get into the program, and he did square away everything he needed to do with his family. So we're going to go in there. We're going to come out with a better perspective on life, work on problems that we have or don't know we have, and come back to you with the review date. And was it 30 to 60 days? I don't know. But when we come back, we're going to.
I'm not following the recommendation, just so you know.
Oh, uh-oh.
I want to see him in a week to make sure he's in that program.
Oh, yeah. That's no problem, Your Honor. That is no problem.
I'm going Friday morning, Miss Washington.
I know
She
you
just-
told me that, Mr. Tallis. You also
Speak up.
I was trying
to go this past Friday, but she didn't have no availability open because of all the people that I guess she got in there. So she told me Friday, but she just texted me like while we're on Zoom now to confirm the appointment. So I replied back with the letter C to let them know that I confirmed for the appointment and the intake.
Mr. Barnett, any input on this one?
I'll leave it in your discretion, Your Honor.
All right, we'll see you back here on May 28th, 2025 at 10 a.m.
Okay.
Defendant to be an inpatient at that point.
Yes, ma'am.
If he's inpatient and they can't bring him, Mr. Mansour,
Yep.
you need to get something from your client giving you permission to get a letter from them indicating that he is an inpatient, okay?
Gotcha, Your Honor. And Martz, please keep me updated. If they say you can't have your phone in there or whatnot, please call me so I know exactly what to do so I can provide it to the court and everybody.
You should
Okay.
have an ROI now so that we have that. Because once he gets in there, if he doesn't have his phone, you can't reach him. So I don't know how you're gonna effectuate that, but you need to get that done so that I can have those proofs. Because if I don't have the proofs, I'm issuing a bench warrant.
Okay, Your Honor, the ROI it's through the inpatient treatment program, right? Or is it through
It
probation?
could be, no, or it could be, I don't know if the PD has their own form, I don't know. But you guys have to figure that out.
Okay.
We'll do that, Your Honor. Thank you so much.
Thank you.
Thank you.
You're welcome. Roll call the matters of Kathleen Serta, 21T11507, 21T11503, 21T11504, and 21T11506.
Paul Barnett on behalf of the township.
Ms. Serta, please state your name.
Kathleen Serta.
All right, we're here for hearing today. Are we having a hearing on this today?
Mr. Greenwood's here. We're ready to proceed.
Have you reviewed her letters?
I did. It mostly relates to communications that occurred after the date of these tickets. So I appreciate that they worked, to some extent after these tickets were issued, but I don't think it's germane to the issue of the tickets.
Well, that's going to take a while, so we won't be doing that first. I'm going to handle some shorter matters and then we'll have the hearing. Mr. Greenwood has reviewed those as well.
Yeah, I believe so. It's the same material, Tom, that you were sent.
Yeah, I'm looking at I was sent some of the notes, and it looks like I have some notes as far as like what happened on which dates or the results of some of my inspections. Again, I'm only privy to some of the information due that I no longer work for Ypsilanti Township and don't have access to it. But I do show some dates and times of what violations existed.
The date of the ticket that I have is February 5th of 2021.
Correct.
Her correspondence begins in, well, the first one is 2020, and then after that is 2021. Where he was still talking about doing re-inspections after.
Well, and the issue is, there's still issues with the property, so they're not going to just issue a citation for failing to bring it into compliance and then just walk away. And I mean, it still has to be addressed. So, I mean, they gave her notice allegedly, and I guess we'll parse that out, but allegedly gave her notice of certain violations for 4 of these properties, and a date by which to bring them into compliance, and she failed to do that, and then issued a ticket for that in February of 2021. They continued to work with her after that. And
So
I think that's where the
her issue is
correspondence.
whether she has notice or not. Okay, all right, we'll deal with that next. All right. Ms. Serta, please hang out until we're done with the shorter matters, and then we'll have your hearing. Ypsilanti Township versus Toriiana Jones, case number 24W00561R.
Paul Barnett on behalf of the township.
Mr. Jones, please.
Toriiana Jones.
All right, this matter is set for a contempt hearing. Mr. Jones failed to appear at the last hearing. He owes $180. We've been doing this since 2024, and no payment has been made. Actually, I guess he pled in 2025, January. Mr. Jones,
Yes.
what's wrong with your payment, sir?
Honestly, I just lost all information because from that last date, I haven't talked to anybody. The phone that I had, I ended up switching that and losing information. And I didn't get any update about any last appearance either. Now, I didn't get contacted by the defender nor a text like I got this one.
Sir, when you were in court on January 8th, I told you that your court date was April 9th. You're required to write that down.
Yes, and I wrote it. I just said I stored it in my previous file and didn't get that information transferred when I switched.
Yeah, I heard you say that. What I'm telling you is it doesn't make an excuse for you not being here.
Well, I normally get texts, so I'm sorry. My apologies.
Sir, you still didn't answer the question about why you paid on your fines and costs. You set up a payment plan of $60 per month back in January, and you didn't make a single payment.
Yeah, I lost the information. Like, I don't like, which court is this? Is this 14A or B?
It's 14B.
That's what I mean. I lost all information of who to pay, what to pay. It's a lot of stuff been going on. I'm not even employed currently because of this, and but I still can be able to get that paid off, I guess, eventually. Soon, not eventually, but soon.
Right, you're here for a contempt hearing as to why you should not do jail time for failing to pay on your tickets. Do you understand that?
Yeah, I guess.
And I'm not hearing why you haven't failed to pay because you know you have two different court cases. You just mentioned both of them, 14A or B or whatever. You can call the court and find out the information.
Well, everything but this that I've had previously is taken care of. So that's why I said I didn't remember which court this was because I lost the information. I was normally getting text and updated by either the defenders, or I would get like the text to appear in court for Zoom like I got for this one. But I didn't get that for the last one at all. So I didn't even know there was a court case. I knew I had payments. I just didn't know to where. So when I got this paper, I've been waiting on this to get the information so I can take care of it now.
Defendant is found in contempt of court. 10 days in the Washtenaw County Jail. I'm going to give you an opportunity to purge that by making payments on your cases so that your next court date is going to be on June 18th, 2025 at 10 o'clock a.m. You need to make a payment on your case, or you can do the 10 days in jail. You'll still owe the money afterwards, sir.
I'll pay the money. You said $180, right?
Correct.
Okay, and if I pay, do I still have to show up?
You don't.
Okay.
Okay, thank you.
Yeah. Me so different.
I'm sorry, what'd you say?
I said I get talked to so different. I'm hanging up.
What we'll call the matter of Al Dunson, case number 24W002470.
Paul Barnett on behalf of the township.
Sir, do you have on a shirt?
No, I'm gonna put one on.
Yes, please.
Okay.
Right, thank you, Mr. Dunson. You're here today, sir, because it's set for a contempt hearing as to why you should not have to do jail time for failing to pay on your ticket.
At the during that time, I think I had to pay, was it April 1st? I had to pay, and at that time my phone was off, and it just got turned back on like probably like last week after my birthday. So it's kind of been a hard month for me trying to get that paid off, but I have a job interview Friday at Trinity Health, so I believe that I could probably get that paid like real soon.
I'm gonna schedule you over to say you have a job interview. Okay, I'll put it out to July 2nd to give you some time to try to pay it, okay?
Okay, how much was it again?
It's $200.
Okay, I can pay it online, right? Great.
Yes.
All right, I'll probably get that paid before July, but I appreciate that though.
All right, July 2nd, 2025 at 10 a.m. It'll be another contempt hearing. So if you don't have anything paid on it by then, sir, you'll probably get found in contempt. So get it done, okay?
Appreciate it.
Thank you. Have a good day.
You too.
All right, the 14B District Court is back in session. The court will recall the Kathleen Serta matters, case numbers 21T 11503, 504, 506, 507.
Paul Burnett on behalf of the township.
Please state your name, ma'am.
Kathleen Serta.
Thank you. All right, today's the time that's scheduled for hearings in these particular matters. And, Mr. Greenwood and Mr. Please raise your right hand to be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. All right, Mr. Barnett.
Thank you, Your Honor. Mr. Greenwood, would you state your name and spell it, please, for the record?
Sure. Thomas Greenwood, Thomas, Greenwood, Greenwood.
And sir, I'm going to direct your attention back a few years ago, 2020 into 2021. At that time, where were you employed?
Ypsilanti Township.
In what capacity?
I believe I was in or either the ordinance officer or ordinance administrator role. I don't recall which. One of the two.
Okay. And working in the ordinance department, did you have occasion to participate in rental inspections?
I did.
Well, and just can you briefly tell us what rental inspections are?
Rental inspections are depending on the time of the inspections and when they took place. Typically, they're both interior and exterior inspections. I believe in this case, during the COVID restrictions, they were only exterior walks of the properties, looking for property maintenance violations.
Okay. And just generally speaking, if you were to do an inspection and observe a ordinance violation, what are the steps?
Typically on an initial inspection, the owners are informed of the inspection. And forgive me with the COVID protocols, I don't exactly recall what how they differed, but typically we would either meet the owner on site to do the inspection. But again, during COVID, I don't think that we had the owners meet us on at the property for the initial inspection. We would do an exterior walk and note what violations were found.
And what were the next steps? So after you found those violations,
So typically the next steps would be a report would be generated and given to the property owner that basically explained to them what the violations were that were found and how long they would have to correct the violations.
And so they would be given a time frame within which to correct these violations.
Yes.
Is there any standard time frame that they're given, or does it vary in each case?
I think it would vary if they were considered life safety violations or non-life safety. Typically, I want to say the life safety were 7 days and the non-life safety were 28 days. However, during the COVID time, I think again, I don't recall what the exact COVID restrictions were, but I believe that they would have been given somewhere around 30 days. Was my best guess at this time.
And so if you would subsequently go back to the property to investigate to determine if they had.
Yeah, whatever reinspection date was determined, then at that point I would return to the property to verify that the corrections either were or were not completed.
And if they were not completed, what would you do at that point?
Typically, I would note that I would make up-to-date notes stating where what had been completed versus what had not been completed, and then typically paperwork would be sent to the owner, informing them of what the up-to-date status of their property was, and then if additional things still need to be taken care of, then at that point we would set up another reinspection date informing them that they still needed to correct X, Y, and Z, and then this is how long we would give them to do so.
Okay. At the reinspection, after you've given them notice, do you have authority to issue a citation?
Sorry, could you repeat that?
If you've investigated or reinspected after you've informed them of the violations and they have not brought the property into compliance, would you ever issue citations?
Yes.
Okay. And the citation specifically is for failing to bring the property into compliance?
Yes, that's correct. yeah, either writing without a valid certificate or failure to correct violations.
And the failure to correct violations is under the ordinance code 48-42, is that right?
I believe so.
Okay. Did you have occasion during the time frame that we've been talking about, late 2020 into early 2021, to be involved in inspections of properties located at, and I'll give you 4 different addresses: 833 George, 835 George, 837 George, and 839 George Place?
Yes, I believe so.
And those properties are located in Ypsilanti Township, are they not?
Yes.
Washtenaw County?
Yes.
Okay. So can you, when, if you recall, when did you inspect these properties? Or when did you first become involved in the inspection of the properties?
I wouldn't be able to give an exact date. Unfortunately, I don't have that information in front of me. I have some timeline, but it's a little sporadic based on I no longer have access to my notes.
Okay. You did compile notes though and document your activities, is that correct?
I believe so, yes.
And you don't recall independently right now, but if you looked at those notes, would that refresh your recollection as to when you did the
I
inspection?
believe so. I have some dates, but I don't recall when the initial inspection has taken place or took place.
Well, if you could review those, and maybe you can just tell us when, at least if it's refreshed your recollection, the first time that you became involved. And there may have been other inspections prior, but.
Yeah, so the first notes that the first date that I show of the information that was sent to me was from 12/2/20. And then it states that very little had been done, had been corrected. Also found multiple windows that had been covered with plexiglass and sealed shut with some sort of epoxy. And then I noted that I emailed the property owner and also called and left a voicemail, is what this states.
Okay, so does that refresh your recollection as to doing this investigation?
Yes, like I said, I don't know the exact date of when the inspection started, but that's one of the earliest dates that I have listed based on the information that was sent to me.
Okay, so let's start at that time then, the
Okay.
earliest that you recall. The date you said, I believe, was December what? December.
I showed December 2nd/20.
Okay. And at that time, did you have occasion to inspect each of the properties that I just listed?
Yeah, it would have been an exterior walk only.
Okay. And those properties, 833 George, 835 George, 837 George, and 839 George, what types of property are they?
They're multi-unit apartment buildings.
Okay. And so this inspection that you were doing, and you don't know what happened, or you can't recall what happened prior to this time, but the inspections that you're doing are for compliance with the rental property ordinances.
Correct.
Okay. And did you have information as to the property owner?
Yes.
And what was your information as to who the property owner was?
I would have had it at the time. I know that there was, I don't know if it would have been Kathleen Serta or if it would have been, I think there's a Teresa Serta as well, but I don't have that information in front of me right now, or I don't have access to that information.
Did you have that information at the time that you did the inspection?
Yes, I would have.
Okay. And you said Kathleen Serta was a possibility of the.
Yeah, that I don't remember. I think I want to say that it was either Kathleen or it may have been like a Teresa Serta. But again, I would have had that information in BSNA at the time. I just don't have it in front of me now.
Okay. If let me ask you this, if subsequent to these investigations or inspections that we'll go through, you issued a citation to a Kathleen Serta, would that have been the person that you had information as to the property owner?
Yes.
Okay. And do you recall whether you had an email or telephone number for that person?
I don't recall. I believe I would have, but I couldn't say for certain.
Okay. And you had a address other than these properties on George Place? You had a separate address for the property owner?
Yes, most likely I would have had her home or the address that was given to us.
Okay. And if you had subsequently issued a citation, that address would have been placed on the citation?
Yes.
Okay. And does review of your notes, well, strike that. Did you investigate or inspect each of the properties that I outlined previously, the 839, 835, 833, 837?
Yes, I believe those are the building numbers. And then there would have been apartments, individual apartments for each unit, but those would have been, so they would have had each building number that you stated would have had multiple apartments associated with that address, with that specific number, but each building that's the number for each building, I believe.
Okay. And so I'm going to look at 833 first. Do you recall what the issues were related to 833? Or does review of your notes refresh your recollection as to what the issues were?
Let me see. See if I can't pull that information up. I have some information regarding that. I show that building, 833, unit 20, window facing north has screws sticking out of the window, sealing it closed.
Okay. And is a sealed window in that manner is a violation of the ordinances?
Yes, because a window would have to have the ability to, a window that was manufactured to open would have to have the ability to open.
Okay. What about building 835?
I see information showing that building 835. Sorry. So unit 12, front picture window, left a front door broken.
Okay. And again, is that a violation of the township ordinances?
Yes, that would be a violation of the International Property Maintenance Code that states that the window would have to be in good repair.
Okay.
Or essentially that the window would need to be in good repair. If there was any cracks or damage to it, it would need to be replaced.
Moving to building 837.
I show unit 10, multiple windows had been primarily sealed closed using plexiglass and epoxy.
So same issue that you had in 833, you have in 837. Is that a fair statement?
Yes, I believe there were multiple windows that were closed that wouldn't have the ability to open.
Okay. And what about building 839?
I show that unit 2 front picture window left a front door is broken, and then unit 5 window facing north has been sealed closed using plexiglass and epoxy.
And again, both of those are violations of township ordinance.
Yes.
Okay. So based on your inspection at that time, did you prepare some kind of documentation or notification to be sent to the property owner?
Yes.
Okay. Was that in the format of like a letter or written document?
Yeah, and again, I believe during the COVID restrictions, all that information would have been mailed to the property owner. Again, in normal circumstances, it may have been also it would have been required that the owner be there and we would physically hand it to them. But there was also cases such as the COVID restrictions that it would have been mailed to the property owner if they weren't present to do the inspection.
Okay, and it's your testimony that you did such a document and it was mailed to the property owner.
I believe so.
Okay.
He's saying he believes so. I need some something more concrete than that.
I wouldn't have access to that due to the fact that I no longer have access to the Ypsilanti Township's BSNA program. I believe Belinda Kingsley is also online. She may be able to speak as to when letters were sent. I unfortunately I'm not privy to that information. I don't have access to it.
So what, I'm sorry, you just said the BS something. What is that?
Yes.
That's the software that we use to track our inspections. So because I no longer work for Ypsilanti Township, I don't have access to it, but perhaps Belinda Kingsley would have access, the director of the program. I do see that she's online. She may be able to speak better to that than I.
Okay. If I could share my screen, Your Honor.
Sorry, I was muted. You may.
Thank you. Okay, can you guys see that? I never can tell. Appears to be a letter.
I can see that.
Mr. Greenwood, can you see that?
Yes.
Whoops.
It's hard to read because it's so small, but I can see it.
Yeah, I tried to, unfortunately, if I make it bigger, it goes into multiple pages. Okay, we can scroll down. Is that a little better?
Yes.
I can try to make it.
Okay, thank you.
All right. Mr. Greenwood, take a look at that. Does that appear to be the document that we've spoken of?
I don't know if that's the document that would have been mailed to the property owner, but that it looks like that would be a description of what was taking place.
Okay, so would they use this does this match what would be generally in the letter that would be sent to the property owner?
The information would be similar. Typically, it would give the building code that's in violation of, and then a description of what the violation was.
Okay. Was there a date by which this needed to be completed?
Yes, it would have been stated on the reinspection letter, or on the letter that was sent to the owner.
Is there a date on this letter, on this information? I guess I'm unclear. Are you vouching that this is the information that you created related to this property after your inspection?
I believe that's the information that I created based off my inspection. Now, for a actual copy of the letter, that's
But
not.
I didn't ask you that. I just said, is this the information that you created after your inspection?
To the best of my knowledge, from what was presented to me, this would have been what I cited during my inspection.
I'm sorry, is that a yes or you don't?
I don't know. I can't figure that out.
I believe so. I don't have access to my information to be able to say for certain.
Well, does it refresh your memory at all? Do you remember this at all?
I remember that I don't remember specific units and building numbers. I remember specific violations such as windows being sealed closed.
I think the question though is whether you remember creating this particular document. Is that the question?
Yes.
I don't remember creating this specific document, but it looks similar to what my recollection is of the violations that were found.
Do you recall giving a date by which this would have to be corrected?
I would have given a date. I don't recall what that date would have been.
Okay.
Oh, actually, no, sorry. It does state on this that life safety violations need to be corrected by 12/4 of 2020. Reinspection date at 1 p.m. That's what the letter states.
Okay, but it also states another date by which issues need to be corrected, does it not?
Yeah, additional issues would be corrected by 1/6 of 2021.
Okay.
Reinspection date.
So it would have been your practice to compile a kind of laundry list here of of violations and a date by which it needed to be corrected, and then document that and take it back to your office? Is that how it would work?
Yeah, typically during that time, I would have taken notes, gone back to my office, wrote out the report, and then had it sent to the property owner.
Okay. And you're saying you don't have access to what was sent to the property owner?
No, I no longer have access to the program.
Okay. Did you, subsequent to the December 2nd inspection, visit the property again?
Yes.
And when was that?
I have notes that were sent to me from December 4th, that the property owner never showed up for the inspection, but TG walked the exterior of the property. I knocked on unit 5, no one home, red tag left asking them to call. Window best TG can tell from the exterior could open if needed, red tag left on the front door.
And I'm sorry, what date was that?
That shows December 4th.
Okay.
And then TG knocked on unit 537, unit 10, met renters. Those windows all open and close. TG knocked on 833, unit 20, no answer. Window appears to be operable. Red tag left on front door. Mailed results to property owner.
Okay. And did you have occasion to go back after that?
Yes. My next set of notes that I have was for 1/8 of 21. No corrections were made. Mailed results to property owner. On 2/5 of 21, no corrections were made. TG issued 4 tickets to the property, or 1 per building, for failure to correct cited violations. Mailed results to property owner. 3/5 of 21.
All right, I'm gonna hold you up for a sec, because these relates to the tickets that we just talked about.
Okay.
So you issued how many citations with respect to this property?
I issued 4 tickets total, 1 per building, not individual unit, but just for the building in total.
And the date of those tickets, what that you issued the tickets was February 5th of 2021, is that correct?
Yeah, 2/5 of 21.
Okay, and did you issued a ticket for each of these properties that we've talked about, 833, 835, 837, and 839, correct?
Correct.
And the alleged violation that you were citing was what?
Failure to correct violations.
And what was that based on?
Based on my inspection of the property.
Okay. And based on your inspection of the property, which you determined what?
That the violations that were cited were not yet corrected, or the property was not in compliance for the violations that were cited.
Okay. And who did you cite for these violations?
I believe Kathleen Serta.
And did you, on the ticket, list an address of the property owner, Kathleen Serta?
I believe so. Yes.
Would looking at the ticket refresh your recollection?
Are you asking the address of where they were mailed to, or are you asking the property of which the violation took place?
No, the address to which they were mailed.
Yeah, I have a copy of the tickets, so I can show that it was that they were mailed. Yes, of what address they were mailed to.
And what was that address?
It looks like 25547 Clark Street, Novi, Michigan, 48375.
And each of those citations was mailed to that same address?
Yes.
And who mailed them? Let me back up. Let me just ask you a different way. When you issue a citation, what is your procedure? What do you do?
Typically I would post a copy on the property, and then I would also have one mailed to the owner.
And is that what you did in this case?
Yes.
Do you do anything with respect to the court?
Yes, then I'll also turn the copy of the ticket to the court.
Okay. So, and did you do that in this case?
Yes.
So that would have been done on February 5th of 2021, correct?
Yes.
Okay.
Or yes, you're correct.
Somewhere in that time frame.
Yeah, sorry, I saw the 2019, but that was the officer ID, not the date of the offense.
Okay. So, and your testimony is that with respect to these citations that you posted something and then you sent it in the mail to the address that you've testified to.
Yes, that's correct.
Okay. You subsequently had a great deal of contact with Ms. Serta. Is that a fair statement?
Yes, I believe so.
Okay. If you issue a citation for someone who fails to bring the property into compliance, is that the end of your role? I mean, is that what?
No, because our goal is to get the property into compliance, made safe, made suitable for the tenant. So a ticket can be a tool if the violation is not being corrected fast enough to try to get it moving along. But even after the ticket's issued, we will still re-inspect the properties and have contact with the owner trying to get the property's violations to be completed.
Okay, and so that's what happened in this case. Is that a fair statement?
I believe so, yes.
Sir, just left the camera for the record.
I apologize.
Now she's back.
I'm here. Sorry.
And you never went to, other than today or the other day when we were here, you haven't been to court on these particular tickets previously?
No, I haven't had any involvement with this case since the last time we were in court.
Okay. I don't think I have any other questions for you.
Ms. Serta, do you have any questions for Mr. Greenwood?
I don't have any questions. I still stand by. I did not receive anything from the township. I mean, this isn't even.
Ms. Serta,
Yes.
this is not your opportunity yet to give your statement. You will have that opportunity, but we're not quite yet, okay? So if you don't have any questions for Mr. Greenwood.
Right. There was a question. At one point, they said that the property, the windows, the life-saving violations, they were corrected. And then after that, they said they sent out the citations. I'm confused about that. The dates that they were giving, because I know I fixed that within 30 days. My tenants, the windows were old in the back. They glued them, did all sorts of stuff. And then they, I had to take it all down. And the tenants took it down too, whatever. I told them to take care of that. And it was taken care of within the first 30 days when he gave me that violation, that notice, when I received the notice anyway, so.
Mr. Greenwood, so first of all, sir, was it your testimony that at some point in time, one of the units had the window repaired?
Yes, there was times where there was part of the violations. I don't have the whole list of the cited violations on there. I know that there was life safety and non-life safety violations. So some of the corrections may have been made, like subsequently the life safety violations, but there still have been additional violations as well. At one point, I do believe that the windows were made safe or were made to be able to open, the plexiglass taken down and the epoxy removed so that the windows could open and close.
So are you testifying that the violation was not for that, but for other issues?
It could have been, again, I cannot recall. I don't have access to that information. I know that again, Belinda Kingsley could pull up the reports that could state everything. I stated what the information that was sent to me, but I don't have access to my files anymore to be able to say for certain.
Mhm. I want to go back to your testimony regarding the mailing of the ticket. So it is standard protocol for you to place a citation on the door as well as place a part of the ticket in the mail to the respondent.
Yeah, so the tickets would have so when you write the ticket, it would have the ability where it would write multiple, I forget what it's called. But one would typically get posted to the door to the property, one would be turned into the court, and then one would be mailed to the property owner.
And you're testifying in this particular case, you mailed that to Ms. Serta.
Yes.
Okay. All right. I don't have any additional questions. Do you have any additional questions based on those questions, Mr. Burnett?
Just briefly, I don't want to belabor it, but you did issue a citation for unit or building 833 for failing to remedy or bring the property into compliance on February 5th of 2021, correct?
Correct.
So at least at the time that you issued that citation, the window issue had not been rectified.
That to the best of my knowledge, again, I can't say for certain without access to the folder to the files. That would be my best guess based on the information. But again, without any access to my files, I wouldn't be able to say for certain.
I
But you
can't,
wouldn't-
yes, just speculation, Mr. Burnett, you know that.
I have something to say. The other day,
Ma'am,
sorry,
it's not your turn yet.
sorry, I just have something important to say. So. Go ahead.
Oh, okay, that's fine. I'm not going to belabor it. I don't have anything else.
Thank you. Do you have any other witnesses?
Apparently I may. I wasn't aware. If I could just have a brief moment with Miss Kingsley.
All right, the 14B District Court is back in session. The court is back on the record in the Kathleen Serta matters, all of them.
Thank you. I would like to briefly call Miss Kingsley.
All right, Ms. Kingsley, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth? I'm sorry, I can't hear you. Ms. Kingsley, could you say something?
Can you hear me now?
Yes, I can.
Yeah, it's a little low. If you can maybe turn it up just a tad.
But I do need you to say yes to the oath again, so it's on the record. You
Yes,
swear, tell the truth, the whole truth, and nothing but the truth.
I do.
Thank you. All right, Mr. Burnett, you're what?
Thank you. Ma'am, could you state your name and spell it, please, for the record?
Belinda Kingsley, Belinda KingsleY.
And ma'am, how are you employed?
I'm employed by Ypsilanti Township,
In what capacity?
Community Compliance Director.
Okay. And that is someone who oversees the ordinance department and investigations or inspections and that type of thing?
Ordinance and rental.
Okay, thank you. And in that capacity, you would have access to the documentation as it relates to rental inspections?
Yes, I do.
Okay. And did you have occasion to at least investigate a little bit the documentation related to rental inspection that's at issue here, building 837 of George Place?
Yep.
Okay, back from December of 2020?
Yeah.
Okay. And did your review of the correspondence reveal any correspondence from Mr. Thomas Greenwood to the property owner as it related to issues that needed to be corrected, or at least any correspondence from December 2nd of 2020.
Yes, I have reviewed that.
And so there is such a document in your file?
Yes, there is.
And what kind of document is it?
It's an email that was sent to the property owner.
Okay. Do you have that on your screen?
I do.
Can you share your screen with the rest of us so we can see it?
Are you able to make it any bigger, Miss Kingsley?
Probably not. It's in this program, we can't adjust the size.
Okay.
Okay, and that's the record that we've discussed that related to this property.
And
I'm would mark this, I guess, as exhibit number 1 and move for its admission.
Any objection to this document being admitted? Ms. Serta?
No, I have this one too.
Exhibit 1 is admitted.
Thank you. And third line in, can you just read for us what that is, Ms. Kingsley? It's pretty hard for me to read here.
the third line says additional issues.
Yeah.
Issues corrected by the 1/6/21 reinspection date.
Okay, thank you. And then below that, it just gives a laundry list of the issues on each particular building.
Yeah.
Okay. I don't think I have anything else for Ms. Kingsley.
All right. You have any questions for Ms. Kingsley, Ms. Serta?
No, I have that email. There's no dispute on that.
Okay.
Okay. Ms. Kingsley, you can stop sharing your screen. Thank you. And again, I don't have anything else for Ms. Kingsley.
Thank you.
I likewise have no additional witnesses.
All right, thank you. All right, Ms. Serta, any witnesses from you other than yourself?
No,
All right.
just my.
And you
Okay.
can tell the court what you like to tell the court at this time.
All right. Well, the other day when I was in court, it was stated that the court didn't have any record of these citations being filed back in 2021.
I never
Yet-
said that.
Well,
What I said was I had no record that a notice had been sent to you in 2020 from this court. And now what I found out is the procedures that Mr. Greenwood sends that to you directly, which is what he testified to.
okay. I never received it. This is not about the money. It's about the principle. I never received it, but even still, even not receiving it, now I remember back, I did have those things corrected within 30 days. So that's probably why he never sent it. I don't understand, how any of this can be proven. And they certainly can't prove service. I know I corrected those issues. If I had my chance in court to defend myself, if I had received those citations, obviously I don't avoid court. I don't, avoid my duties. I've taken care of everything. The township even said I didn't show up in court, something that Belinda Kingsley stated. And I was, surprised that she even said that, because I didn't even know of a court date that I was supposed to show up back during COVID. I mean, I don't understand. I just don't understand, because I never received any notice. It was COVID. It was a pandemic. I'm here in Novi. I know I didn't receive it. He's got my email. You can see the emails don't state anything about any citations. I have my phone number, my address, of course. He said that he sent it to, but he doesn't really know. He can't give you a sure, confident answer on that. I didn't receive it. That's all I can say. I don't know how to prove that I didn't receive it any more than they can prove that they sent it. And I think that's where we're at right now. And if they need me to defend myself on my property, I did the work. Some of the things that they kept listing were stuff I couldn't work on in the winter, you know, when it came to concrete, but I got it all taken care of. I did everything. I mean,
Ms. Serta, first of all, I want to be very clear. You're here for the entirety of everything today. Whether you
Right.
did, let me finish speaking, please. Whether you did the work and whether you received the proper notice is all what's before the court today. And we've scheduled this hearing. This is your day and time to do that. I set aside the defaults because I did not have notice that you had received them. So we're here for the entirety of this case. So you're talking about if you're talking about if you had the opportunity to defend yourself. This is the one and only opportunity you're gonna get.
okay. Well, I'm defending myself. I don't have much else to say except that, you know, I didn't receive the notices. I didn't receive any citations. I did address all the issues, and I didn't that they sent me through my emails. I took care of everything. That's all I can say about it, and they know that. So I don't have anything left to say except I never received any citations.
All right, well, the bottom line is whether you receive them or not, I'm giving you an opportunity to show that you corrected them by the time you were issued this ticket, and you haven't proven that to me.
No, that I passed the exterior inspection a long time ago. They have that on record.
All right.
They know that. Boy, definitely. That's a given. That's been 4 years now. I already passed the exterior inspections and interior.
Are you hearing me? Are you hearing me, ma'am?
Yes.
I'm gonna repeat one more time. And if you don't talk over me, maybe you can hear what I'm saying.
Right.
You need to prove that you passed the inspection prior to February 5th, 2021.
Right. February 5th, 2021. Gosh, wow. Well, we're going back a while.
Your Honor.
Yes.
I was able to find an email from, it looks like November 9th of 2021 that shows that I stopped by the property on 11/9/2021 to see how the repairs were coming along. Many of the violations were in compliance, but here is a list of the few. But there are still a few things that needed to be things that are needed before you can pass your inspection, and it shows each building and what violations were still present during that time, and that there would be a reinspection date set for 12/8/21.
So she hadn't passed, and it's your testimony that she hadn't passed inspection as late as November of 21.
November 9th of 21 is when this email was sent, and then she responded, I keep working on the place. When I come out, my mom's going through many treatments but getting better. Things just keep breaking. It's very difficult to keep up. You'll have to have patience with me on this one. I spend a fortune on the windows. The cameras are being finished today. That will help me with the blight. Had a bunch of expensive furnace repairs and a number of sewer backups, which will be required. The expensive jet clean out twice a year, not to mention the increase in the water and the gas. I'll be doing a small rent increase at the first of the year. It won't be enough, but it may keep things going. Just be patient. Believe me, the tenants are not as fussy as you are, and neither are aren't as fussy as you are, and neither of you are as fussy as I wish I could be. Thanks. And that came from Teresa Serta.
Thank you.
Well, I don't know. I don't know about the citations. All I know is I never received them, and I have no way of proving that. But I did what I've been working on that building. Boy. I mean, if they want to charge me, I'll just pay it. I'm done with this. I don't need any more court dates or anything. You want me to pay because I have no way of proving that I didn't receive citations. I worked on the building. It was COVID. It was a national pandemic. My mom was going through multiple treatments, and I was diagnosed with breast cancer. But You need the 600, I got it. I'll be out tomorrow and I'll pay it, okay? I'm done with this. They want to nickel and dime me to death. I'm okay with it. That's it. That's all I have to say about it. I do my job. I take
Your
care of
Honor,
things.
if it would help, I can share this screen that shows the email.
No, she actually submitted the stuff herself saying the same
I
thing.
just want to make sure because there was a number of violations for each building, so that show that there was additional violations. So when I was going through it, I just found it, so I wanted to make sure to be clear.
You're very clear. We're
Okay.
all right. Anything else from you, Mr. Barnett? If not,
No, Your Honor.
all right. I find that she was in violation of the codes and had not come into compliance. The tickets amounts stand. So the total is $624.
No, I can't hear nothing.
I'll let him know we can't hear him.
All right.
Yeah, it doesn't look like he has his mic on for you.
Yeah, I can't hear nothing.
Let me recall that. I think the poly was off.
That's good.
Can you hear me now?
Yes, Your Honor. You talking
Mr.
to me?
Deanne? All right. Yeah, I'm going to recall the case. State of Michigan versus Mohammed Deanne.
Good morning, Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Mohammed Janen, who appears via Zoom from the MDOC facility. Sir, can you please state your name for the record?
Mohammed Janen.
Thank you, Your Honor. I have discussed this matter briefly with my client this morning. He was recently transferred to a different MDOC facility, so to that end, I was unable to visit with him either via video or in person prior to today's date. So I'd be requesting a brief adjournment so that can happen.
What's my due?
2 weeks.
You want the 4th or the 18th? Well, it's 2 weeks exact on the 4th.
Yes, sir.
Maybe.
Maybe the 18th.
Sounds good, Your Honor. Thank you.
I'll adjourn the matter June 18th, 2025, 9 a.m. Bond will continue. Thank you, Mr. Dane.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of the people versus Sarah Orr.
Ashley Lonnie for the people.
Sherilyn Foster Tucker on behalf of Sarah Orr.
Or Your Honor.
Thank you. All right. What,
Gregory first.
briefly, yes. Never gonna get through this. In fact, we've had a bench conference in this case.
Yes, Your Honor, and there has been an offer extended to the defendant to plead to an added count of failure to report $1,000 damage accident, 90-day misdemeanor, $100 fine, and 0 points, contrary to MCL 257622. In exchange for that plea, count 1 will be dismissed.
That is correct, Your Honor. And Ms. Orr does wish to accept that offer today. And I have handed the court an advice of rights form.
May I have her sworn, please?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Sarah Orr.
No. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of failure to report an accident. It's damage over $1,000. That's a misdemeanor punishable by up to 90 days and a $500 fine plus court costs. You understand that?
Yes.
All right. Understanding that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
All right. You
Sorry.
signed an advice of rights form. Is that correct?
Yes, I did.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
Because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On May 22nd, 2024, at the location of Moon Road near Michigan Avenue, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
All right. Were you involved in an accident?
Yes, Your Honor.
What happened?
So I was in the yield lane or the merge lane, whatever it's called. And the other guy was in the through lane, and we were at the red light. And when we were driving through, I got in front of him, and then he got into the turn-in lane. And then he says he was going to turn, but I don't think he was, because of the way the damage is, he hit the front of my car and the front of his car. So he was trying to get back in front of me.
You're
But then
you're heading north.
Correct.
You were heading toward Ann Arbor.
No, away.
You were heading away from Ann
So
Arbor.
south.
So you were coming past the Walmart,
Yes,
heading out.
right. Where State Street turns into Moon Road.
Yeah.
Yeah.
Okay. All right. And so you had this collision. Did you immediately stop your vehicle?
I did not. I was a little scared, so I did not.
Okay, you didn't stop. Did you immediately report that to the nearest and most convenient police
I did
station?
not.
You did not. Would you dispute that the aggregate amount of damage that can include repair cost was in excess of $1,000?
For mine or for his?
Total.
So you obviously don't know how much his vehicle.
Right, correct.
But would you dispute that if he says it was more than 1,000, would you dispute that?
I didn't see the damage, so I don't know.
We can stipulate that it
You'll
was over
stipulate that
1,000.
the damage, total amount of damage to both vehicles was in excess of 1,000, including repair costs. You'll stipulate to that, counsel. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
We're satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
June 25th. At 9 a.m.
June 25th, 2025, 9 a.m.
And Your Honor, I do not expect a restitution. I do believe the insurance covered everything.
Covered everything. Okay, fantastic. All right. Thank you. All right, bond will continue. You'll stop down at probation on the way out. Just
Okay.
check out. All right.
Okay, thank you.
Thank you, Your Honor.
Thank you. Court does call the case people versus Michael Clustra.
Ashley for the people.
Morning, Anna Uberdas with and on behalf of Mr. Clustra standing to my right. Mike, please state your name for the judge.
Michael Clustra. All right.
We have an adjourned plea trial, had discussions with Ms. Landy. May counsel approach, please.
Yes, briefly,
Thank you.
folks.
Today's the day.
I got a whole
I
lot
know.
of cases.
Thank you, Anna. We're looking for another adjournment if we could. I don't know how long Ms. Landy thinks it might need to be.
I will accommodate the defense counsel schedule.
I'll do the 18th, 2025 at 9 a.m. If you think what you're working on is going to take longer, then let the court know and we'll figure that out.
Thank you.
Very
All
good.
right. Thank you. Court does call the case people versus Gabrielle Boyd.
Ashley for the people.
Good morning, Judge. Rita Spahich on behalf of Ms. Gabrielle Boyd. Judge, I had a very lengthy conversation with my client last night. I am quite shocked she's not here this morning and very, very surprised. I'm hoping that she's okay. So I'm just asking if you could just pass it for a moment. I've been trying to get in touch with her, but this is quite shocking. She's been here every single time. So I hope that
So it was a good conversation?
yes, very good
Okay, all right.
conversation.
I don't know. Maybe you were yelling at her.
No, it was not anything bad. That's
No,
why I'm a little
okay.
bit, I'm a little bit worried about it. If you could just pass it.
I'll pass.
Thank you. I appreciate it.
Court does call the case people versus Rebecca Dworth.
Ashley for the people.
On behalf of Ms. Dilworth, not sure she's logged into Zoom yet, Judge.
And Your Honor, I have prepared a nollie in this case. If she's not, I don't know if the court's received it yet.
I don't have Ms. Dworth.
With the case, Judge, we are asking that the court excuse her presence. We are expecting a dismissal from the people anyway.
You're moving to dismiss.
That's fine, yeah. It works on its way. It should be hearing that now.
Okay. No, thank you, Judge.
Case is dismissed. Thank you. Court calls the case of the people versus Zachary Burlet.
That's the line of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burlet, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Zachary Burlet.
There he is. Okay.
Thank you, Your Honor. I have discussed this matter with the people, and it was my understanding that this was going to be a dismissal. Oh, sorry.
What did she say?
Just getting my notes pulled up there.
Oh, okay.
One moment to drop my screens. That's correct, Your Honor. We are going to be dismissing this case.
Certainly no objection to that.
Case is dismissed. All right. Thank you, Mr. Burlet. Take care.
Have a good day.
Thank you, Mr. Burlet.
Court calls. Cases of the people of the state of Michigan versus Jason David Allen. All 9 of his files.
Ashley Lundy for the people in all matters.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Allen, who should be present via Zoom from Don Parham. Sir, can you please unmute and state your name for the court?
Jason Allen.
Thank you, Your Honor. There is a resolution of all 9 of these matters today, Your Honor. I don't know if Ms. Lundy would prefer to put the resolution on the record, or I could do so.
I am happy to do that. Your Honor, start 22410696. The defendant will plead no contest to this charge to retail fraud in the 2nd degree.
Hang on. Which case?
696.
696. He's pleading no contest
As charged.
as charged. All right. Got it.
698.
Yes. He's doing what?
No contest to an added count of retail fraud in the 3rd. Dismiss count 1, count retail fraud 2nd.
That's no contest to that charge also.
Yes, sir.
They're all no contest
Yes.
from the reports I read. Okay. I hope they are. All right. Go ahead.
697.
Yes.
They'll be pleading no contest to an added count 2 of retail fraud in the 3rd degree, dismissing count 1 retail fraud in the 2nd degree.
All right. Okay.
328.
Yes.
They'll plead no contest is charged to retail fraud in the 3rd degree.
Okay. Okay.
And lastly, 278.
Yes.
They'll plead no contest to an added count 2 of retail fraud in the 3rd degree, dismissing count 1 retail fraud in the 2nd degree.
Okay.
Case 699. And don't please, the dismissal cases now, 699.
700 and 2419. And then 218 would be dismissed.
That's correct. Restitution for all cases and all counts.
So basically he's pleading to 5 counts of retail fraud 3rd degree.
1 retail fraud 2nd, 4 retail fraud 3rds.
Okay, hang on a second. Got it. Okay, 696, he's pleading to retail fraud in 2nd degree.
Exactly right, Your Honor.
Why, I don't know, but is that correct? Is that a correct statement?
Yes, it is, Your Honor, and that is what I discussed with my client, and that is what he would like to do today.
All right, Mr. Allen, raise your
Yes,
right
sir.
hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name for the record, please, sir.
Jason Allen.
All right. Mr. Allen, it is this court's understanding that you are going to be pleading no contest to 1 count of retail fraud in the 2nd degree That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
And that also you'll be pleading no contest to 4 charges of retail fraud in the 3rd degree. Those are misdemeanors punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would be the maximum fine. You understand that?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, Your Honor.
All right, 2 things about a no contest plea is that I have to make sure that you understand is that first of all, it means that you're not further desirous or wanting to contest any of these charges. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea in these cases?
Potential civil liability, Your Honor.
All right. So, sir, to the charge of retail fraud 2nd degree, how do you plead?
No contest, Your Honor.
To the charge of retail fraud 3rd degree as contained in the case ending in 698 with an offense date of March 12, 2024, how do you plead?
No contest, Your Honor.
To that same charge of retail fraud in the 3rd degree contained in the case ending in 697 with an offense date of March 17, 2024, how do you plead?
No contest, Your Honor.
To the charge of retail fraud 3rd degree as contained in the case ending in 328 with an offense date of 8/29 of 2023, how do you plead?
No contest, Your Honor.
To retail fraud 3rd degree as contained in the case ending in 278 with an offense date of November 27, 2023, how do you plead?
No contest, Your Honor.
All right, now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct, sir?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
All right. Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am a participant of Judge Kunke's drug court.
All right, so you're on probation. Well, were you on probation at the time of any of these offenses?
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will?
Yes, Your Honor.
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report in the case ending in 696, the report number 23-14001. In the case ending in 698, the public safety report and case number 244086. In the case ending in 697, court has reviewed the police report 244362. In the case ending in 328, court has reviewed the police report and police report case number 23-12936. And in the case ending in 278, court has reviewed police report ending in 2318100. Since I've read all those, counsel, is there any objection to the court having reviewed those reports?
No, Your Honor.
No, Your Honor.
All right, the court in each of those reports does find a sufficient factual basis in which the court could find the defendant guilty of the offenses as alleged, or sufficient evidence of defendant's guilt in those cases. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas in all of these cases to count 2 or to retail fraud second in case 696, and in the other matters to retail fraud third. The other cases, as indicated on the record, are no longer with me. Those matters are dismissed. All
Thank you,
right.
Your Honor.
Defendant is referred to probation for pre-sentence investigation and report. Sentencing in these matters will be June 25th, 2025, 9 a.m. Defendant's bond in all of these cases will continue. Mr. Allen, I need you to wait online. We're going to put you into a breakout room with my probation department so that we can begin the sentencing process. Okay, sir?
Thank you, Your Honor.
Thank you.
Thank you, Mr. Allen.
Thanks, Natalie.
What's all that? Court, let's call the case of the people versus Sean Turnley.
Candidate Siller on behalf of Ditchfield Township.
Which one's in the ring?
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Turnley. Mr. Turnley, please state your name for the record.
Before we go on to the other case, Mr. Turnley, you have a new matter before me. That case alleges that on or about March 24th, 2024, at the location Carpenter Road in Pittsfield Township, that you did possess drug paraphernalia. You understand the nature of that charge, sir?
I do.
And that's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that, sir?
I do.
All right. Do you wish to be represented by an attorney?
I do.
All right. This is a public defender case.
Your Honor, pertaining to the arraignment, we'll waive formal reading and stand mute to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea.
As for all the pretrials, we're asking to adjourn all of them. Mr. Turnley is up in court, and we're kind of just seeing what happens on those. His next dates on those are June 5th.
Right.
Well, he has some May 29th. The latest date is June 5th. So I'm asking,
June 18th date?
yeah, I'm asking
What a date after those?
after June 5th, right?
All right. So, well, on his new case, I'll order standard conditions: no assault behavior, no possession of weapons, no alcohol, recreational marijuana, or any illegal drugs. I'll adjourn all of these matters then to June 18th, 2025, 9 a.m. Bond and the other matters will continue.
Thank you, Your Honor.
Thank you.
Thank you. Court calls the case People versus Stephen Grisbeck.
Candidate Siller on behalf of Ditchfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Grisbeck. Mr. Grisbeck, please state your name for the record.
Stephen Grisbeck.
What are we doing?
Your Honor, we're asking for an adjournment of this pretrial of the possession of drug paraphernalia case.
Okay.
He's currently serving a sentence on his domestic violence case. I've been in communication with, and just, I guess, for the court's knowledge and Mr. Grisbeck's knowledge, I've been in touch with Ms. Pilara. He's at risk of losing his Section 8 housing. I know Mr. Bernstein handled that DV case. I know the court's aware of that. So she may, if he continues with the domestic violence classes, may move up his review hearing to June. They recommend that the court.
We were trying to move his case closer so his certificate or in the house wasn't in jeopardy.
I have 9 days before the 93 days is up.
I have him in custody for 55.
Your sentence is up in 9 days?
The voucher.
Oh, the voucher. You have 9 days left on that.
Are you saying that because of the amount of time you've been in custody?
So how much longer do you have on the DV classes? I'm doing the ones in jail.
Yeah, I already did 5 classes.
How many are there?
There's 12-week class. I've already done 5 of them.
You're about halfway through.
Correct.
All right, so I know we were trying to get him to a certain point so they didn't lose that, but so I'll adjourn this pretrial to June 4th, 2025, 9 a.m. I don't want to go, if we have to do another adjournment, we'll do it, but you've been in contact with Miss Blair.
Yes.
Okay. Okay. I don't know where you guys are in your discussions, but then have Miss Blair get in touch with me so we can see if we can maintain his housing security.
Okay.
Okay.
I appreciate it. And if I may ask, is his bond on this case personal bond? If we do resolve the DV case issue?
I do, yes.
Okay.
I think the last time we were talking about his housing, I set a PR in this case.
Okay.
So that everything will be clear.
So if I get released, would I be on a GPS tether, correct, on the DV?
I'm not sure under what terms we would do the release.
Okay.
Or that we're going to do it even. I know that we were trying to make everything work out for you on that. Okay?
Thank you.
All right, thank you. Oh. Court recalls the second time, case People versus Gabrielle Boyd.
Morning, Judge Ada Spahich, on behalf of Ms. Gabrielle Boyd, who's present via Zoom. Judge, again, thank you so much for passing this matter.
Ms. Boyd, can you state your name, please?
Yes, Your Honor, Gabrielle Elise Boyd.
Your counsel told me to issue a bench warrant. She told me, she said, go out and find her. I had faith that she'd show up. I'm just letting you know.
I'm so sorry, Your Honor. I would never leave you guys. I would never do that. I would never stand off like that.
Thank you, Judge. I appreciate it. Fire me and then what are we going to do then?
The reality is your client, your counsel stood up for you and had me pass it and everything and had me not issue the bench warrant.
I appreciate that so much.
Thank you so much, Judge. Last time we were here, we adjourned the pre-trial because I needed some time for discovery. I have received all discovery. I have reviewed it. I am speaking with the sister counsel with respect to just if there's a way that we can resolve this case. There might be some potential legal issues in the case. I just needed some more time to discuss it with Ms. Landy because we might be able to resolve it short of me filing a motion. So that was just going to be a quick adjournment, and I wanted to address the bond as well, Judge.
All right. So will the 4th be enough time for you? Or
so, Judge, this is another thing. If I could, I know. I'm sorry, Judge. I know.
No, go ahead.
We're
taking all day with this case anyway.
I know. I might as well, I am going to be going out of town to visit my family back home in Bosnia. So I work when I'm there as a sole petitioner. I can't really take a lot of time off. So I work while I'm there. So I'm going to be appearing via Zoom. If you could give me the June 18th date, just because I'm traveling on that 3rd and 4th, it takes a long time to get there. If you could give me the 18th date, I can appear via Zoom. If this is okay with you, Your Honor, and obviously allow my client to appear via Zoom. I will be working. I will be in communications with Ms. Landy.
That's fine. We'll do that for you.
Thank you, Judge. I appreciate it.
All right. June 18th, 2025, 9 a.m.
Thank you, Judge. And
as your invite indicates, yes, that's the bond.
Just with the bond, yes. Judge, you previously granted my client a request to travel with her family on a cruise starting tonight, until May 31st.
I did that?
Yes, Judge, that was granted. However, I did not take into consideration the travel time back from Europe. So she's actually coming back June 1st. So I was going to ask for just that one additional day. I didn't want her to just assume that she can come back on June 1st without asking you directly, Judge.
I'm trying to see. Did I sign an order? I did. Okay. And so you travel. So your travel date is the 1st of June.
So we fly back the 31st from Barcelona, but apparently time-wise, since they're 6 hours ahead, it will be the next day. So that's what my mom told me, at least, is that we will be arriving early on the 1st, but we will be departing for travel on the 31st.
You know what? You've got till June 2nd to get back. I'm not going to do international datelines or anything. I'm done with that. So you have till June 2nd.
Okay, I'll for sure be back by June 2nd, for sure.
Perfect, Judge. And then one more request, and I will leave you alone,
wow.
Judge. I
Really?
swear, I know you're gonna make
Really?
fun of me. At least I don't come here
It's
that
my
often.
fault.
No,
So,
you don't.
You know,
but
so
when you're here, there's a lot of requests. Go ahead.
yes, Judge. So my client has twin sisters who are,
What?
who have their last performance as the lead of their Broadway musical in New York. So the whole family is going to that
What?
show from June.
So they're
6th
going to
through
Barcelona and New York.
No,
in June.
so
That's in
mine-
June.
Yes.
So that's from
mine-
June 6th to the 9th, and I'm respectfully requesting that you allow my client to travel to New York with her family from the 6th to the 9th to attend the show, the musical, that her twin sisters are participating in.
So hold it. She's going to Barcelona. She comes back. I've
Correct.
given her to June 2nd.
Correct.
She's then gonna like basically catch her breath and then she's off to New York.
And then,
Yes,
yes,
which is
my-
gonna be very tough because I travel to Europe quite a lot and it's exhausting.
My twin sister's been the lead of a Broadway musical for the last year and a half. Her
So
last.
hold on. It's not your, so it's your twin?
It's my twin sister. She's my twin.
Oh,
yeah.
no.
Sisters, not her
There's like two of them.
Yes.
Well, there's like five.
Well,
of-
she-
there's
there's-
five daughters.
I know, but there's 5 daughters?
I believe so,
Yes.
right, Miss Boyd? Okay.
Yes,
Wow.
there's 5 of us total, and she is extremely hardworking, a U of M musical theater graduate. It's really important to her that I be at her last show. She's expressed to me, and
She
I also
wants her twin there?
she has stated that to me very clearly that she wants me.
So I'm supposed to do this for her?
For me, Your Honor, because I would really love to be there to support her. I would be traveling via train with my grandfather to take him because it would be his last opportunity to see her. So
Oh,
it's
okay.
yeah.
You sold me. I'm done.
Okay.
I'm done.
Thank you, Ms.
What
Boyd.
dates, what dates are there?
June
June
6th to June 9th. We will be back the 9th.
Council, if you can prepare an order.
I will, Judge.
Like just, that includes both of your clients.
I will make sure I prepare a new order.
All right.
It'll include both, and I'll make sure I file that today.
Thank you.
Thank you, Judge. Thank you so
Take
much for your
care.
patience. Thank you, Ms.
And
Boyd.
Godspeed to all of you on your journeys.
Thank you so much, Your Honor. I appreciate you.
You're welcome. Court calls the case People versus Carl Tinsley.
People,
Is that what Johnson was here on?
yes.
Is that, you gotta watch, Ellen, did you see him sitting over there in the corner? He was hiding. He comes in here and hides. Go ahead.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Carl Tinsley, who's approaching from custody.
They're bringing. Your name, sir?
Carl Tinsley.
Thank you. Yeah, just step over. Yeah, there you go. All right. Okay, what are we doing?
Your Honor, we ask this matter be set for jury trial.
All right. Jury final settlement conference, June 6, 2025, 9 a.m. Jury selection if necessary, June 9th, 2025 at 8:30. Both of those proceedings are in person.
Your Honor, I'm sorry. I'd like to speak.
Oh, okay, hold on. Yeah, counsel first.
I have jury selection Lawrence Buckner in the Ypsilanti District Court on June 9th.
Jury selection?
Yes, Your Honor.
Before Judge Barr?
Yes, Your Honor.
It'll be here.
Okay.
We all select on the same day.
All right.
So.
Your Honor, if I may, so Mr. Johnson and I have a fundamental difference in strategy. There's no point in us moving forward together on this case. Mr. Johnson is representing me in circuit court. I've submitted a motion to have Mr. Johnson removed his counsel in that case.
Why?
Excuse me?
Why?
Why? Because Mr. Johnson is totally uninterested in this case, in that case, in this case
Mr. Tinsley, you've been before me before, and I'm just gonna tell you this.
Okay.
I haven't known Mr. Johnson necessarily all that long.
Okay.
But I'm gonna tell you for maybe about the past year plus that he's been appearing before this court, there has not been a client that he has walked into this court where he has not been interested in their case and zealously representing his defendant. So I don't believe you. You coming before telling me that about this attorney? I don't believe it for 1 minute, not 1 minute. I think, because you've been before, is that you're probably not listening to him. He is advising you. I can guarantee he's protecting every right you have.
And you'd be absolutely wrong.
Fullest.
I have not seen, this gentleman has told me he's gonna show up to see me countless times at the county jail. He has not. I've been waiting over 2 years for discovery in another case at all. This gentleman doesn't answer his phone. You're making these assertions without having personal experience.
I'm done.
He
done.
If you want to file a tool for defense.
If you want to file, Mr. Tinsley, you're done. You're done. You are done.
Yeah, I think I need to respond to the 2-year comment. Mr. Tinsley does have a matter that's been pending for 2 years. I'm the 4th attorney on that matter.
I know.
I have only been representing him since April. When I go to speak to him, he doesn't want to talk about what I want to talk about, Giannis.
I know.
I just want to clear that up for the record.
And Mr. Johnson, I meant my words sincerely. I've dealt with Mr. Tinsley before. This is a game we play. So I'm done.
All right.
You're still on this case, regrettably, but you're still on it. All right. Take care, sir. Court does call the case of the People versus Daniel Sims.
Councilor Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Sims, who is approaching. Please state your name for the record, sir.
Mr. Sims, Daniel Sims, sorry.
Thank you, Your Honor. I have discussed this.
I'm not all the way awake, I'm sorry.
So you don't know your name? All right, no, go ahead. You're all right.
At least you said Mr. Sims. I mean, it's still correct.
I just repeated her, I'm sorry.
So, Your Honor, I have discussed this matter with my client as well as the people. We are wishing to set this case for final settlement conference at this time.
All right, jury final settlement conference for Mr. Sims will be June 6, 2025. 9 a.m. Jury selection, if necessary, June 9th, 2025 at 8:30. Both of those proceedings are in person.
Thank you.
All right. Thank you.
Thank you, Your Honor.
Go back and get some sleep.
Okay, we are on the record in the matter of the City of Wyandotte versus Gregory Benson.
Right, Your Honor.
25256, 241644 A and B, 241407, 241659, and 241644C. Okay, counsel.
Your Honor, Neil DeBlois here on behalf of Gregory Benson. On all 4 of these matters, Mr. Benson appears via Zoom from the Wayne County Jail. Mr. Benson, are you able to hear us? Would you please state your name?
Please unmute, sir. In the meantime, appearance for the people, please.
Roger Keeley on behalf of People City of Wyandotte, Your Honor.
Okay, and Mr. Benson, please hit unmute on your device there, please. Mr. Benson, can you hear me? I just asked you to please hit unmute on the device. Do you see the little button that popped up? Okay, Mr. Benson, can you please grab a deputy, please? Oh, he's handcuffed, so behind his back, so he can't unmute. That's my fault, I didn't know that.
Yeah, we're gonna get you back.
Okay, sorry, Mr. Benson, I didn't realize you were handcuffed. So, Mr. Keely, did you place your appearance on the record?
Gregory Benson.
Okay, thank you, Mr. Benson. All right, and so council, we did have an opportunity to speak in chambers with the prosecutor and yourself, and, council.
Here's your honor. The court will recall that I filed a motion to order treatment to restore competency for cases 24-1407, 1644, and 1659, as well as to order a new competency exam 25-256. This motion is based entirely upon the report from the Department of Health and Human Services dated April 17, 2025, that all parties are familiar with. In that, determination was made by that facility that with respect to his competency, that he was presently incompetent, the correct term, although maybe it is possible that he can be brought back, his competency can be restored. Based upon that finding, which we presently dispute, interpretation of the statutes, court rules, and health code, that the court has the ability and the authority to order Mr. Benson into treatment, which is what we're requesting. Further notation that my interpretation of the statute, since this is a misdemeanor, the maximum length of treatment that is permitted is either 15 months or 1/3 of the maximum sentence. There's 3 cases, but each one of them has a maximum sentence of 93 days. Positions that can't be accumulated, so it's at this point, I believe the court can order 31 days of treatment in an effort to restore competency. With respect to the case 25-256, he has not been determined incompetent, and the move here would be to order a new competency evaluation with respect to that case, because at this point, he's not capable of being arraigned. It's my understanding that the court is intending to simply adjourn that matter until we have a direction on the first 3 cases and whether the effort to rehabilitate Mr. Benson is going to be successful. So I don't have any objection to that.
Okay, so what the court's going to do, Mr. Keely, Mr. Keely, do people stipulate to the report, or the findings of forensic psychiatry?
Yes, Your Honor.
All right, the court is going to then deem Mr. Benson incompetent based upon stipulation of the recommendation from the Center for Forensic Psychiatry. The court is also going to find that Mr. Benson is likely to attain competency, again, based upon the report in finding from CFP. The court is ordering Mr. Benson to receive mental health treatment. We will schedule this matter for a review. So I did the math, and in 31 days, counsel puts us at Tuesday, June 17th. Oh, no, wait, hold on. I lost my math. One days puts us at June 21st. June 22nd. So that's post that. So we could do June 23rd, which is a Monday.
I'm here.
You're here, Mr. Keely is not. We could also do Wednesday, June 25th. But we're past the 31 days
Right.
on both of those days.
Oh, Mr. Keely needs to be present, that would be.
Right, the other option is if you can, I know you're not scheduled for the 18th, but if you can zoom in on the 18th of June, council, then that would be before the 31 days, just like 2 days shy of that.
I'm momentarily. I can do that, zoom in on the 18th.
Okay, yes.
just thinking, we can have forensic center, see if they're gonna do any follow-up.
Yes, you'd have to do that, yes. And what time works for us on the 18th?
9:15.
All right, 9:15 a.m.
Sorry, Judge, I didn't catch that date.
June 18th at 9:15.
Okay.
Okay, so I'm going to, so I can talk to Stacy about how we have to do what we have to do. What's that? Oh, you need me? Okay, just a minute, we're gonna go off here. Okay. Mr. Benson, we're all done with Mr. Benson. Mr. Benson, you're all set. You can let the deputy know that you can go back.
When I go back to court,
June 18th.
where's my charges?
The same as they were. You didn't get any new ones.
What am I charged with?
Public intoxication, alcohol out in public. Those are your charges, sir. And
Why can I go home? Why can I go home?
because the court has ordered, you've been deemed to be not competent, sir, and the court's ordered you to receive mental health treatment.
What is mental health treatment?
Well, sir, I apologize, but I can't go into all of that right this moment, but there's a doctor there that can go into more detail with you. So you're gonna be back on June 18th. Hopefully you can start the competency.
What is competency?
Where you understand all of the proceedings and that your behavior is not appropriate.
Is that like selling cocaine in Detroit?
No, not even close.
Oh, sir. Y'all ready to go back up? Yes, sir. Take down Benson, Rich. Take down Benson back to Cleveland. Take down Benson back. Take down Benson back. They killed my brother. Fuck Michael Miles, punk. Fuck the facts and all. Fuck you too, bitch. Put your contacts on and put the gun on your ass, bitch. Put your ass.
Keep these messages down, please.
Yeah.
Ready, Greg?
Yes, sir. Oh, bitch, what the fuck did you? Fuck the coat up your ass. Take that green
Wait,
deputy.
Just so you're aware, just so you're.
Take that up, though, man. Take that back. You'll have to put that mattress out your ass. Put that coat tag, the compass in red blood on the coat tag. Could it help me, sir?
Yeah,
Just so you're aware, Mr. Benson was sitting in there,
I see.
so you may want to get adjusted. Thank you.
Thank you.